Please the court, I appear for the applicants in matter 21405 together with Ms. Blizzard and Mr. Kalani.
Yes.
Please, you may not. I appear together with Mr. Wicks and Mr. Choko in case number 29984 for the applicants.
Thank you.
And please, the court, I appear together with Mr. Skakani for the respondent in the Democratic Alliance application and for the second respondent in the EFF application.
Thank you.
Yes, when we were in chambers, Advocate Clark said something that she wants to raise in court. Have you been given a proof of service of the record?
No.
Not yet. What are your instructions?
My instructions are to ask for the respondent in order to give the third respondent an opportunity to file papers in this matter, and the orders directly to affect the third respondent.
Where's your application?
We don't have an application. We don't have a substantive application at this time.
If there's no application before us, then we cannot entertain that application. Because there's no application before us.
Will we be given time to bring an application?
No, you knew about this matter since about August. And in chambers, you told us that even last week you knew that the matter was on the roll. I think you had ample time to file it. And why did you file it last week when you knew that, or a month or 2 months ago, when you knew that the application, that these matters were set down for today and tomorrow?
I don't have instructions as to why the respondent application was not filed. We were still trying to investigate as to what had transpired, as to why we had not received any documents in the matter. So that we were trying to do. When we found out last week that it was set down and it's indeed our matter as well, that's when we were trying to see what had happened. So at that stage, we didn't do a substantive application. Because at that stage, we didn't even know that the matter was active yet. According to us, there was only founding papers filed in the application.
You've given me a letter dated the 22nd of August in which you state that the notice bears a different case number, and then you think that this matter does not pertain to the third respondent, your client. Now, yesterday, when you phoned me, what made you to think that this matter pertains to your client?
Because they told us last week, Thursday, that this matter does pertain to our client, and it indeed is this matter that's before the court. So hence we then started running around trying to figure out what had happened and why we had not.
Now, from last week, Thursday until now, why did you not prepare a substantive application for the postponement?
I don't have any instructions on why.
You don't have any answer for it?
Well, no.
Very well.
Even yesterday you should have done that. Because by yesterday you were quite well aware that this is the matter which you should be involved in.
In our view, we don't have any application before us, and then if indeed you wanted to file an application, you had ample time to do that, and we ruled that we are going to proceed with the two matters before us. Right. Thank you. Yes, we may proceed. As we have indicated in chambers, we are going to hear submissions in respect of the matter of the DA. Thereafter, the EFF will follow, and then there would be responses by Mr. Masuku.
So, in order, just to put myself on record, together with my learned Judy and Mr. Bangwa, we appear on a washing brief for the presidency in both matters.
Okay, it's noted.
Appear for the defense, so in the EFF matter.
Okay, thank you. Noted, Mr. Mabena. Then let's proceed.
Thank you. Thank you, Justice Ndlovu. For the convenience of the court, we've prepared a further chronology which we hope can act as a convenient or helpful roadmap in the argument and expedite. May I hand 3 copies out. Justices, at the outset, it's helpful to draw a broad timeline in this matter and to point out certain milestones which we believe are important. And they are reflected in this chronology, and the point of departure is in on 20th June 2005, the National Director of Public Prosecutions, Mr. Vicarious, announced that the fifth respondent, Mr. Zuma, was to be charged on 2 counts of corruption. So that was June 2005, as per the chronology. The following year, in September 2006, the High Court in Pietermaritzburg struck the criminal matter off the roll on the basis that the prosecution was not in a position to proceed with the matter. And in the course of the remainder of 2006 and 2007, there was, as the justices, interlocutory litigation relating to the validity of various search warrants and the validity or an attempt by the prosecution to get the court sanction for a letter of request to obtain certain information and evidence that had been obtained in Mauritius. And by the latter part of 2007, the Supreme Court of Appeal had found that the various warrants had been properly issued and had found that the letter of request was properly to be sanctioned. And that had the result that effectively the obstacles such as they had been to the prosecution of Mr. Zuma in 2006-2007 were out of the way as far as the prosecution was concerned, with the result that in November 2007, the decision was taken by the National Director of Public Prosecutions to re-indict Mr. Zuma. So that was the second decision to prosecute. November 2007.
But that was a fresh indictment.
Yes. In September 2008, the Pietermaritzburg High Court per Nicholson J upheld the challenge by Mr. Zuma in terms of Section 179 of the Constitution, directed at the lawfulness of the decision to re-indict. That was September 2008. In January 2009, the Supreme Court of Appeal overturned the decision of Nicholson J, and that had the result that on 1 April 2009, the National Director of Public Prosecutions decided to re-indict. And that decision to
wait, Mr.
re-indict
Rosenberg, you say on the 1st of April 2009?
The National Director of Public Prosecutions decided, Nicholson J's decision was on the 12th of January 2009, upholding the challenge. On 1 April 2009, the National Director of Public Prosecutions decided to discontinue the prosecution in the wake of that judgment. And on the 13th, well, shortly thereafter, in fact, the challenge to that decision to discontinue the prosecution was launched by the DA in April 2009, and on the 13th of October 2017, 8 years later, the Supreme Court of Appeal upheld that challenge to the lawfulness of the decision to discontinue the prosecution. And on the 16th of March 2018, this year in other words, the National Director of Public Prosecution announced the decision to re-indict Mr. Zuma on a range of charges. So that is broadly the roadmap which for present purposes is of significance in this matter. We have set out our argument in the heads. I'm not going to take the court through the heads in any detail. In our submission, the primary question in this matter is whether the decisions taken by the accounting officer in the presidency to fund Mr. Zuma's personal legal costs was authorized under Section 3 of the State Attorneys Act. We know that the Rule 53 record reflects a variety of decisions taken at various times by the accounting officer in the presidency from 2003 up to date to fund those legal costs. And we know that those decisions, although there is in correspondence from time to time an indication that Section 3.3 of the State Attorney Act may form a proper basis or an alternative basis of funding decision, we know that the presidency has indicated in this matter that the decisions have to be assessed on the basis of Section 3.1 of the State Attorney Act. And we submit that for the reasons I'll deal with, Section 3.1 doesn't provide proper authority, and to the extent that any reliance could be placed or should be placed upon a statutory provision which on the face of it wasn't relied upon, we would say similarly Section 3.3 doesn't support the decision. And we say that if there is in fact any other legal basis that could support a decision, that can't avail the presidency and Mr. Zuma in this matter once it has been made clear that there was a deliberate intention to act in terms of Section 3.1 of the Act. And in our submission, if the court were to find that Section 3 does not authorize the decisions, then the court needn't consider the further arguments that we've put up and further reasons why it said that the payments were unlawful.
So is it your submission that the interpretation of Section 3 may be dispositive of this?
Yes. If the interpretation of Section 3 is as we contend it to be, that is in our submission dispositive of the matter, and the court needn't decide the other bases upon which it's contended that the decisions which effectively have emerged in the answering papers are lawful, and what would have to be then be required is the question of a just and equitable remedy, and linked to that the question of whether there has been an unreasonable delay which ought not to be sanctioned or ought to be taken into account in formulating an appropriate remedy.
So the whole debate about that there were 6 requests, but it doesn't appear on the record, on the face of the record, that there were 6 authorizations, that then doesn't come into play.
That won't come into play in that event. We're still going to go through to the extent necessary individual decisions to hopefully illuminate why Section 3 doesn't find application, but primarily to illustrate that even if Section 3.1 were to find application for the reasons that we will point to in each case, any such decision was bad. And we're going to begin by addressing the scope of Section 3. We will then go on to deal with the chronology of the various requests for funding. As far as Section 3 is concerned, does the court have a copy of the bundle of authorities? But I don't think so. May I hand up 3 copies of that? The relevant extract from the State Attorney Act 56 of 1957 is at page 5 of that bundle. And we will refer in particular to Section 3.1, thereafter to Section 3.3. Section 3.1 in our submission is plain in its purpose and intent. It provides that the State Attorney shall perform work on behalf of the government. That is, where the government, which we accept includes a public official cited in their public or official capacity, is a party to the proceedings, the State Attorney is authorized to act in terms of Section 3.1. The Minister of Police cited in his official capacity the claim of vicarious liability. Section 3.1 appropriately authorizes the State Attorney to act. In the present matter, we know that the government was not a party to the criminal proceedings. It was Mr. Zuma, in his personal capacity, who was the accused in those proceedings. And in those circumstances, and for that reason alone, we would submit that the State Attorney, where a decision was taken, and we'll come to that in due course, to authorize the State Attorney to act in the pre-indictment stage of the matter, that where the State Attorney acts in terms of Section 3.1, the State Attorney is acting in circumstances where the government is a party to the action. Section 3.3 extends the matters in which the State Attorney can act, can provide legal services. It operates in connection or in connection with any matter where the government, though not a party, is interested or concerned, or where it's in the public interest, in the opinion of the State Attorney, that the functions be performed at the said office or one of its branches. So, even if the government is not a party in appropriate circumstances, Section 3.3 authorizes the State Attorney to provide its services, provided it's in the public interest or the government interest to do so. Now, in the present matter, certainly in relation to the decisions post-indictment, post the 2005 indictment, the state funding was provided in order to enable a private attorney to act on behalf of Mr. Zuma, not the State Attorney. And we submit that Section 3.1, certainly, and equally Section 3.3, is not a provision which authorizes the State Attorney to outsource its functions to a private attorney. On its own wording and ambit, those provisions are empowering sections defining when the State Attorney is to act. Yet, in fact, that's exactly what happened in this matter. There was, from the time of the 2006 request, or in fact even before that, as you will see, effectively an outsourcing of legal functions that was contemplated, and that's what the funding was sought for.
In that period, was Mr. Zuma an official of the government?
Mr. Zuma, at the time that the requests were made, he was a government official.
When was it?
Well, if one goes back to the chronology, if I can just take you through the chronology just to remind ourselves, Justice, you'll see that Mr. Zuma was appointed as the MEC of Economic Affairs and Tourism in 1994. In 1997, he was elected as the Deputy President of the ANC. In 1999, he was appointed Deputy President. And at the time of the pre-indictment requests for funding, and at the time of the 2006 request for funding, Mr. Zuma occupied the position of Deputy President.
And that is before he was asked to resign.
Yes. The resignation, I'll find the date of the resignation for you and get back to you on that, Justice Ledoir. So, the first submission accordingly is that Section 3.1 doesn't find application where the state attorney is not acting in the matter. The request for funding is essentially to enable a private attorney to act.
Let me just come in there. When considering or interpreting Section 3, do you consider the time when the request was made for legal services, or do you consider the time when the conduct was committed?
We would submit that would go to the question, the Section 3.3 question, essentially. Is it in the public interest, or does the government have an interest sufficient to warrant the state attorney to act? That would be the question.
But will the latter apply?
No.
Whether the government has a sufficient interest, because there it seems to me that can only be in matters where the government is not a party.
That's right.
Whereas in every single matter here, including the criminal prosecution, the government obviously was a party.
The government is a party in that sense, yes. So
that doesn't apply. We are really looking at public interest or not.
Yes, that's correct. So to answer your question, as to the relevance of the date of the request, or the relevance at the time at which the allegations took place, we would submit the date of request for the purposes of Section 3.3 is not relevant. For the purposes of Section 3.3, clearly this is a case where the government is not a party, and the government must consider whether it's appropriate, the sufficient government interest, or it's in the public interest. Now, the first submission then being that Section 3 doesn't permit the outsourcing of the state attorney's functions. That's the primary submission that we make. We say that even if the court were to find that Section 3.1 does permit the outsourcing, Section 3.3 for that matter, we say that nonetheless those sections don't apply for the following reasons. I've made the point, section 3.1 doesn't apply because Mr. Zuma was a party to criminal charges where he was being sued, or he was the accused in his criminal capacity. No question that the government was being sued in this matter, or the government in that sense was a party to the matter, and that he required, or it required funding in an analogous situation, for example, where the deputy president was sued on the basis, some or other basis of vicarious liability or something like that in civil procedures. We're not dealing with that situation. We're dealing with a situation where there's a criminal prosecution against Mr. Zuma in his personal capacity. And the state attorney was being requested to act on his behalf, not on behalf of government. As far as section 3.3 is concerned, we've made the point that that is not the statutory provision which is sought to be relied upon. And I'll get back to that, where we see in explicit terms when the first request or first decision was made to fund Mr. Zuma. I'm referring to a decision that was taken on the 14th of December 2005. And that decision was taken on the basis of, explicitly on the basis of section 3.1, and I'll get back to that. But section 3.3 doesn't apply in our submission because of the nature of the charges which are preferred against Mr. Zuma in the charge sheet. The charge sheet is at Annexure DM2 at page 636 to 643 of the record. And the charge against Mr. Zuma was essentially that he obtained undue financial benefit in the form of 783 payments from Mr. Sheikh, Mr. Sheikh's companies, and certain French arms dealers who were interested in certain contracts in exchange for wielding so-called informal political influence. The charge sheet reads at paragraph 72, page 38. It said, accused number one's assistance to Mr. Sheikh as described and his anticipated assistance was informal and it didn't form any part of the official bidding selection process. So it's thus clear from the charge sheet that engaging in the corrupt activities in question, Mr. Zuma was not involved in furthering government business in any form. The expectation is that he would influence or exert his influence informally. And perhaps the most useful and readily applied test in this regard is to have regard, or to evaluate the question of whether the individual concerned was acting in the course and scope of his or her employment as a useful tool in these circumstances for determining whether there's a various acts of corruption. And in paragraph 11, Cleaver J, in that context, page 60 of the bundle, says, in my view, there are also grounds for concluding that the ruling or order made by the first respondent can be set aside in review, because the order is either irrational or unreasonable. This was a matter where, curiously enough, in the course of the criminal proceedings, the presiding magistrate had, contrary to a decision which the relevant provincial authority had made, had decreed that funding should be provided for the further conduct of the criminal proceedings. And for reasons which are not germane, Cleaver J held that that decision was bad. But in paragraph 11, and this is relevant for present purposes, he says, there are also grounds for concluding the ruling or order can be set aside. And he goes on to say, to deal with the question of vicarious liability. And in the middle of the paragraph, he said, in relation to a presumption that the respondents were innocent and until found guilty, he says, the two respondents are innocent until proven guilty. That is so, but in my view, the presumption doesn't justify the ruling that the first respondent was to provide legal assistance for them. As to the official capacities in which the two respondents occupied, it would seem that the first respondent was of the view that the applicant ought to fund the defense of the two respondents because the applicant would in some way be vicariously responsible for the actions of the two respondents. Vicarious liability generally applies when an employer is sought to be held liable for the deed committed by an employee acting in the course and scope of his employment. The two respondents are not being charged with offences under the Corruption Act and fraud committed on behalf of the applicant. They're being charged in their personal capacities, and vicarious liability is not an issue. And the second authority that we've referred, or in fact, I think the EFF has referred to Governor's case. I'm not going to take the court there. Governor's case is at page 191 of the bundle. But there, Felthays and Jay, in a short judgment, dealing similarly with the case where members of the South African Police Services had allegedly been guilty of fraud and corruption, said the following: it's clear to me the fact that the applicants are members of the SABC placed them in a position...
Which paragraph are you reading?
I haven't in fact referred your lordships there, or ladyship there. It's page 191 of the bundle.
Paragraph 9.
Paragraph 9.
Okay, thank you.
It's clear to me that the fact that the applicants are members of the SABC placed them in the position to commit the offences and crimes as alleged. The conduct on which the prosecution rely can, however, by no stretch of the imagination, be described as acts which were performed within the course and scope of their duties as employees of SABC. It has nothing to do with the duties and functions which they are by statute required to perform. And one can, perhaps, by way of analogy, refer to a situation where, for example, a member of the police services is trying to arrest somebody that he or she reasonably suspects of being guilty of unlawful activities, and in the course of attempting to carry out that arrest, acting bona fide and believing that the action is warranted, does something which may amount to a crime or an alleged crime. If the member is charged in those circumstances, bona fide having acted in the course and scope of their employment, one can understand there why, as a matter of public policy, it may be considered inadvisable that that individual would have to fund his or her own defense. That's an entirely different situation from what we're dealing with here. So we say that in these circumstances, where conduct which is unrelated to government business, carried out purely for the own advantages and ends of the individual concerned, carried out where the individual, in terms of reaching this agreement with Mr. Sheikh, is not in any way busy with government activity, cannot fall within Section 3.3, even if that were the provision which the presidency has sought to rely on, which, as we say, it has. So, in summary, then, we say that even if the state's payment to private, or the state's payment of private legal costs can be authorized under Section 3, the objective requirements of that section are not met.
But Mr. Rosenberg, my understanding is that the state also paid adverse costs orders against Mr.
Yes, we will get to that as well. And that's an important and entirely distinct matter as well. That's right. Going back to the question of when Mr. Zuma was dismissed as deputy president, it was in fact on the 14th of June 2005. So much in relation to Section 3 of the Act. Some reliance has been placed, we don't understand how much, on Treasury Regulation 12.2. We don't, with respect, understand how Treasury Regulation 12.2 comes into the matter at all. It is at page 9 of the bundle. Following 12.2, page 23, sorry, the actual provision. And 12.2, with respect, doesn't take the matter any further. It doesn't govern the provision of legal assistance or the payment of private legal costs incurred by officials at all. It has an entirely different effect as we understand it. It provides for the state to accept liability for loss and damage caused, for example, by the police or omissions of officials in the course and scope of their employment, without recklessness and without influence of drugs or alcohol. And essentially it provides or indemnifies the officials for civil damages claims where they've acted without any intention to cause harm or willful recklessness. So, to the extent that there is a passing reference to Treasury Regulation 12.2 as read with Section 3.1, we fail to see how that advances the matter, and our submission, it has no bearing on the question that we're busy with in the courts, in this matter.
Sorry, Mr. Rosenberg. So, Section 3.1.
Yes.
From the statement that you have just made, my understanding is, or reading it, I understand it to mean that the state will provide, or the state attorney will provide legal services.
Yes.
And not legal fees.
That's right.
So, in that interpretation, how then did the state attorney provide Mr. Zuma with the legal fees? That will be my question.
Yes, for example, and we'll get to this, where an instruction, where a decision was taken that the state attorney could act on behalf of Mr. Zuma in the trial of Mr. Sheikh and provide legal services in the form of a watching brief. As it happened, we know that despite that being the authorization, a private firm acted. But nonetheless, to answer your question, the state attorney will then act. In the course of the state attorney acting, it may authorize certain disbursements, whether they're to the deputy sheriff or to counsel, or whatever the exigencies of the matter require, where the state attorney is authorized by Section 3 to act. But the objective requirements of Section 3 must be met before the state attorney acts, and thereafter one can have regard to exactly what the state attorney, the nature and extent of the legal assistance provided.
Having answered that in that manner, then my further question would also be, there is allegations by the respondent that the decisions were to pay over those legal fees were made by the president or in the presidency. How do the two then relate? The state attorney in terms of the State Attorneys Act and the presidency?
Well, the state attorney, as we'll see, is authorized by the presidency to act. Requests are submitted for legal assistance on behalf of Mr. Zuma. Those requests are in the first instance directed to the presidency. The accounting officer in the presidency, ultimately in each case, as we will see, makes a decision. And that decision at various times was that the state attorney should act and could act on behalf of Mr. Zuma in terms of Section 3.1. So that's essentially where the 3.1 decision gets made in response to various requests for legal assistance which are directed to the presidency.
Yeah, without trying to drag it out, I'm just trying to understand, because now your explanations makes me ask more questions, because if the decision is to be made by the presidency, wouldn't the request have been through the presidency to the state attorney? The decision made by the state attorney, but it comes from the presidency, isn't it?
Yes.
Shouldn't it have gone the other way around?
Yes.
The president should instruct a request from Mr. Zuma to represent Mr. Zuma.
Yes, we'll see that in fact that is how it happened. We'll to the extent necessary go through each of the requests, and I anticipate that should illuminate exactly what happened. And perhaps we could then, in the light of that, go back to this question as to who made the decision, who ought to have made the decision. So, if we can then, perhaps with the benefit of the chronology.
Maybe before you take us to the chronology, it's tea break now. We'll adjourn for 15 minutes and we'll be back at 11:30. Court adjourns.
We have
He's a member of something. The tuna salad, something like that. Chicken and tuna
Can you hear me? Can you hear me? How good Linux?
I want to see the salad.
Testing 1 2 1 2.
So No, I'm not sorted. I'm still a bit you can just
Rise in court.
May I proceed, Mr. Rosenberg?
Justice, I'm now turning to address, as we say, the additional ground on which the DA contends that the payment of personal costs are unlawful. And I'm going to do this moving through the chronology that we've prepared. And in relation to certain of the requests, I'm going to move quite swiftly. We've documented the relevant references and the relevant requests. And I'm going to start off on page 2 of the chronology. The first two requests are in bold: the funding of Mr. Zuma's response to NPA questions, that was in March 2004, and the funding of Mr. Zuma's team for a watching brief at the Sheikh trial. Those are both requests that are made at a time or pre-indictment. And as far as the funding of the request for the response to the NPA questions, it appears, as we've said there, that there was no evidence of a final decision by the Director General in the Presidency to approve that funding, to whatever extent that funding was provided. We refer to a letter of motivation of the 9th of March and a view of this Chief State Law Advisor in 20 April 2004. But the upshot of that is this is not funding directly for the defense in the criminal trial, and it's pre-indictment funding, and that's what one can make of that. The next item was the funding of a legal team to hold a watching brief on behalf of Mr. Zuma at the Sheikh trial. Perhaps, before I go there, can I just briefly then return to the first item, the response to the NPA questions. That we submit was unlawful because it appears that no final decision appears to have been taken. And secondly, we've made the point already that if it was authorized, it was on the basis of Section 3.1 or 3.3, and those requirements were not met. There could be no conceivable legal interest, public interest in the state funding Mr. Zuma's personal costs in responding to warning questions from the NPA. None has been pleaded, and none appears from the record. So the second example, or the second funding example we have, is the funding of the watching brief. And again, I'm not going to take the court through the chain of correspondence in that event, but Justice Kabish, in relation to the question that you raised, this is an example there of the request being made to the Presidency, the Director General in the Presidency considering that request, and instructing the state attorney in that case to act and to brief counsel.
But the state attorney at the end of the day is the decision maker.
Yes. Well, it depends. It depends in relation, for example, to 3.3. There may be a situation where the state attorney makes a decision that it's in the government interest that it should act. In this particular case, where the funding is provided on the basis of Section 3.1, in terms of 3.1, as what ought to have been the position may be one question. What we know in fact happens here is a decision is made in the presidency in terms of Section 3.1 that the state attorney must act, and an instruction to that end is given in terms of Section 3. That's what actually happens.
But it must be always open to the state attorney to refuse to act.
Well,
if he disagrees. Isn't he the final decision maker?
Well, it's
as
not,
the EFF contends.
Yes, the state attorney would be at large, certainly, to say that this is not a matter where the government is a party. This is a situation where effectively the accused is not a party who is the government, is being charged in his private capacity. Yes.
Well, Mr. President, just correct me if I misunderstand the structure. Yes. But my understanding is, at the end of the day, all the expenditure, actual expenditure incurred, would be financed by the department requesting the assistance.
Yes.
And therefore, it must be first approved by the DG.
Yes.
And then, because at the end of the day, that department is going to foot the bill. And then the request goes to the duly approved by the DG, goes to the state attorney, and the state attorney is the final decision maker.
If one accepts, and one must accept, that the state attorney is in a position to say, I can't act in this matter, Section 3.1 doesn't cover me.
Yes.
Yes.
But it did not do that in this case.
As far as the funding of the watching brief is concerned, again, in the context of what's just been discussed with the court, here was the situation where the DG and the President instructed the state attorney to act. And
here the state attorney didn't act. Here the state attorney appointed another set of attorneys.
The state attorney didn't act, appointed Ms. Mohammed as a private attorney. We know that she charged 108,000 rand, and that, of course, even on the term, was outside the terms of the mandate or instruction that the presidency had given. Then the first request for the funding of Mr. Zuma's criminal defense is dealt with at page 3 of the chronology, and we say there that on an assessment of the exchange of correspondence that took place at that stage, that funding appears to have been approved by the Director General in the Presidency for one senior counsel and one junior counsel, subject to certain conditions that are articulated in the letter from the DG, Mr. Fowler. We've referred to that at page 4 of our chronology. So this is in relation to the first request for the funding for the criminal proceedings. There the funding was approved. It was explicitly stated that the decision was taken under Section 3.1. A draft agreement was provided to be concluded by Mr. Zuma with the requested undertaking. And the authorization was again to the state attorney to instruct a particular level of counsel, and the caveat was that private attorneys could be appointed only if absolutely necessary and with the approval of Mr. Farmer. So that was an earlier request. It appears that no undertaking was given, if one has regard to record 56 of the Rule 53 record, and that decision in those circumstances never became an effective decision. The conditions weren't met, and not a decision that can be relied upon as a lawful decision for funding purposes, aside from the Section 3133 arguments. That was the position up to December 2005. In July 2006, Mr. Halley put up a request for funding on behalf of Mr. Zuma. That was a request for private funding, and that appears to have been approved subject to a request or a requirement by the Chief Operating Officer that an undertaking to repay is received. Now, in those circumstances, what happened in relation to this funding was that there's a memorandum which one sees at page 56 to 57 of the Rule 53 record, which does confirm or certainly indicates that a decision was taken to fund Mr. Zuma's criminal defense, as reflected in the request and undertaking of the 14th of September 2006. We've referred to that undertaking at page 5 of the record, of the chronology, but the fact of the matter is that Mr. Zuma's criminal prosecution was struck from the roll in September 2006. So, in those circumstances, what then happens is that through the latter part of 2006 and 2007, the question of the lawfulness of the warrants, the search warrants, was being determined in the High Court, in the Supreme Court of Appeal, as also the question of the letters of request. And as we've indicated, the matter then, the next step in the chronology, after the 2006 striking off of the matter, was in 2007, after the Supreme Court of Appeal had upheld the lawfulness of the warrants, 29th of November 2007, the National Director of Public Prosecutions re-invited Mr. Zuma. But before that occurred, there was yet another funding request. Again, this is at a time when the matter had been struck from the roll. It was a funding request for an interlocutory application regarding or in relation to an interlocutory application in respect of the letter of request, we deal with that at page 5 of the chronology. And that was approved subject to an undertaking to repay an estimate of costs and a cap on the number of counsel that were to be employed. And the State Attorney had notified Mr. Halley of the Presidency's conditional approval of that request. And that is at the Rule 53 record 64 to 65. That was on the 22nd of March, and we've itemized that under this particular item that we're dealing with, the funding of the request for assistance in the interlocutory application. And what is importance in this context is that the State Attorney emphasized that funding was provided for the interlocutory application subject to the provision of an undertaking and subject to an estimate of costs. And furthermore, given that the criminal prosecution had been struck from the roll on the 20th of September, this funding was considered to be separate from any approval which had been given previously in relation to the defense of charges which had now been struck from the roll. So this was accepted as being necessary in the context of the funding steps. Separate application, separate approval, given that the charges had been struck on the 20th of September 2006. And the next item in the chronology is inaccurate, the 31st of June 2007, the Constitutional Court judgment. If the court could just make a note of that, and I apologize for that. That was, in fact, it was the Supreme Court of Appeal on the 8th of November 2007.
At what page are you at?
At page 6, we're dealing with the item which is there reflected as 31 June 2007. This is in the context of the request for assistance in relation to the letters of request. That item is incorrect. It should read 8 November 2007. The SCA's judgment in relation to upholding the warrant and sanctioning the letters of request. Yeah. For what it's worth at this point, the Constitutional Court decision was in June 2008, confirming that again. But just in the context of this chronology, I make that correction. And it does appear, from what we can see, that Mr. Zuma failed to meet the prescribed conditions of the COO's approval of 19 March on this item. No undertaking was furnished, no estimate of costs was submitted, and obviously it appears that the same limitation, or the limitation regarding the extent of the team, was not complied with. We know that ultimately Mr. Zuma lost this, his opposition was dismissed, he lost his case and was ordered to pay the costs of that particular application. But as things stand, we don't see any undertaking having been furnished as was required in the approval for that particular funding. So, thus, even had it been open to the presidency to fund that litigation on the basis of Section 3, the COO's conditions in March 2007 were not met. The third request for funding was specifically for the criminal defense, That was in January 2008. And we deal with that chronology at page 6. In December 2007, and this was shortly after, it was in fact December 2007 that the Constitutional Court confirmed the validity of the search warrants and the search and seizure warrants, and shortly thereafter the National Director of Public Prosecutions re-indicted Mr. Zuma. And this prompted Mr. Zuma's third request for legal representation in his criminal trial, and that we see in his letter of the 14th of January 2008, page 6 of the chronology. And it's clear that Mr. Hulley recognized that in the wake of re-indictment, it was necessary now to obtain a fresh undertaking. That's in line with what had happened hitherto, and that was the tenor of Mr. Hulley's request of the 14th of January. And again, moving through the relevant correspondence under this item, it appears that on the 12th of September, which we referred to at page 7, it appears that after negotiation between the parties on the structure and the rates for Mr. Zuma's legal team, the presidency then approved funding, defense subject to a new application and a new undertaking for repayment. And the presidency's letter to the state attorney of the 12th of September, which we've referred to at the foot, or in the middle of page 7, you will see there that the presidency advised the state attorney that the accounting officer had instructed the state attorney, again, given the instruction to agree to a specified fee schedule for Zuma's team, so it's for a particular team to be appointed, and again subject to an undertaking to pay. And it makes it clear that the presidency's agreement to fund legal costs incurred in the preliminary application of 4 and 5 August only in the event of the applicant being successful. So
the preliminary applications being the Mauritius request?
No, the preliminary application at this stage was the application in terms of 179 to challenge the decision to re-indict. So that's referred to as the section 179 application, and we know that that application was ultimately dismissed in the Supreme Court of Appeal, and Mr. Zuma's application for leave to appeal to the Constitutional Court was refused. So, for the reasons stated, the presidency's decision in 2008 to pay for the criminal defense was unlawful, since Section 3 doesn't apply. Even if that decision was lawful, Mr. Zuma is clearly obliged to repay the state for the legal costs incurred in the interlocutory application to challenge his re-indictment. Unsuccessful in that matter, and contractually obliged to repay. But we emphasize, and I'm going to get back to this in due course, we emphasize the fact that in each case, after there is a dismissal or removal from the role or a decision to discontinue a prosecution, when Mr. Zuma is re-indicted, a fresh application is considered going forward because circumstances have now changed. Charges are modified, different circumstances prevail, different legal teams are in the picture. Initially, I think it was Ms. Lombard in 2005, Mr. Haley motivates in 2006 for a specific team for a specific purpose. And again in 2008, we see a motivation in the wake of the decision to re-indict for a particular team, particular costs, for a particular purpose, and in particular circumstances.
Is it your submission that the state attorney was supposed to have claimed the fees that they've paid after this application was dismissed?
Yes, it certainly was the undertaking.
But we all know that they did not do that.
Yes.
So do you want this court, is also one of the prayers,
yes,
that this court should make such an order?
That we will deal with that in the context of appropriate and effective relief in the circumstances, and I'll get to deal with that.
Okay.
So I wish just to emphasize that, and that's why at the outset I drew attention to the various phases of this criminal prosecution. Then, staying at page 8 of the chronology, we know that in April 2009, the acting NDPP, Mr. Mshe, decided to discontinue the prosecution of Mr. Zuma.
It's the 1st of April.
1st of April
not the
2009.
8th, yes.
And thereafter, the DA instituted its application to review Mr. Mshe's decision. That gave rise to a request for funding for Mr. Zuma's opposition to the DA review. We know that that review had a protracted course from 2009 to 2017. There were no less than 3 hearings, both in this court and in the Supreme Court of Appeal, and ultimately that decision to discontinue the prosecution was set aside. But there was a request for funding for Mr. Zuma's opposition to that decision, to that review. In November 2009, Mr. Haley, and at the foot of our chronology, submitted a request to the state to fund Mr. Zuma's opposition. And on the 11th of February, we've referenced it again over the page, page 9 in the chronology. On the 11th of February, Advocate Sahodi, Legal Executive Services in the Presidency, sent a memo to the COO in the Presidency, Ms. Duarte, recommend that the Presidency approve the funding on the request, on the basis that the DA's review application was inextricably linked to the withdrawn criminal proceedings. And the assumption, if one has regard to that letter of 11 February, is that the request fell within the ambit of the state's undertaking to pay for Mr. Zuma's costs. That memorandum, as we've recorded in our note on the 11th of February, appears to have been approved by the COO. That decision we submit as bad for a variety of reasons. Again, we repeat, it's not authorized under Section 3 of the Act. Mr. Zuma was acting in his private capacity in that matter. Moreover, the government nor the public could have any interest in Mr. Zuma's private opposition to the DA's review of the NDPP's decision, especially since the NPA was itself opposing that application and thus defending its own interests and any other government interest that could possibly be relevant. And secondly, and even if the decision could have been authorized in terms of Section 3, we say that the COOs and the State Attorney, as it happens, their belief that it was inextricably linked to the criminal prosecution and was within the ambit of the undertaking was clearly incorrect. It was erroneous and inconsistent with the terms of the 2008 decision to fund the defense. That was limited to, as we've pointed out, as reflected in that letter from Advocate Vicarious on the 29th of August 2008, just going back to the 2008 funding. You'll recall that on the 29th of August, Advocate Vicarious had indicated that the presidency was prepared to fund the criminal defense, but in doing so didn't assume liability for incidental and interlocutory applications. And we say that in those circumstances, there didn't appear to have been any consideration of the merits of Mr. Zuma's private opposition to the DA application or its relevance to the main charge. The COO and the State Attorney just seemed to assume that the two were inextricably linked and that the request was already encompassed by the 2008 undertaking, which it clearly wasn't. And we say, for those reasons, in addition, the 2000 or the funding of Mr. Zuma's review of the opposition to the 2009 review was bad. Now, and equally, and perhaps a further rider, of course, if Mr. Zuma's private opposition to the review was lawful, i.e. unauthorized under Section 3, then of course he's nonetheless obliged to repay the costs of his application in terms of the undertaking. He was unsuccessful in that review application and he's bound by the undertaking to repay. Now, perhaps one of the most, if not the fulcrum or central point of this case is the decision taken this year by the NDPP to re-indict Mr. Zuma. That was on the 16th of March of 2018. The NDPP decided to reinstitute the charges to re-indict Mr. Zuma. And it appears from the papers that the presidency is going to continue to pay for Mr. Zuma's legal costs, and it will do so unless the court indicates that it's not obliged to do so, whether in the form of the declarator and or in the form of setting aside any decisions to the extent that that is required. And the presidency's position is based on the understanding that it remains bound by its 2008 decision. I'm going to read an extract from the presidency's answer. The court will have seen it in paragraph 29 of the presidency's affidavit at page 144, where Mr. Labisi said the following: the presidency continues to provide state funding for former President Zuma for his criminal trial. It does so on the basis that the decision is presumed to be valid and binding until it's set aside by the court. The continued finding is therefore subject to the finding of the court as to the lawfulness of the decision. Now, we say that approach is misguided and erroneous for a number of reasons. Now, firstly, the 2008 decision to fund, like the previous decision to fund, was then overtaken by the withdrawal of the charges by the NPA following National Director of Public Prosecution Share's decision in April 2009.
But those charges were reinstated.
Yes,
they were reinstated.
They were later, Mr. Zuma is then re-indicted, as we know, in 2018.
Yes, but the Supreme Court of Appeal set aside the decision not to continue the prosecution.
Yes.
So once that has been set aside, surely the initial indictment stands.
What in fact we know happens is the matter was dealt with on the basis that representations were made. The National Director considered the matter, considered the lapse of time, considered the evidence, and then made a decision in the wake of that process to re-indict. That is effectively what happened and what his March decision confirmed. So
you say it's a fresh indictment?
Well, in those circumstances, one must regard it as a fresh decision, not only just from a practical point of view, given the lapse of time and the changed circumstances, and fresh submissions made on behalf of Mr. Zuma, whether in fact charges should be pressed against him. In substance, then, a fresh decision is made, taking all those factors into account, and it was announced as such. And we say that in those circumstances, regard being had to the previous history of the matter, for example, the striking off in 2006, equally in this instance, the undertakings that had been given in the past related to the then criminal proceedings in place, and that is the case in relation with the 2008 undertaking. Even if, aside from the arguments that we've made, it could be construed as being lawful, we say even on its own terms, it clearly was an undertaking to fund particular charges at a particular time, at particular rates, a particular team. It was, with respect, never contemplated that it was going to, as it were, re-emerge 10 years later after the NDP's decision to re-indict. And yes, perhaps if one goes to the 2008 decision, yes, at 81 and 82 of the Rule 53 record, we could turn to that. If you turn to page 81, one sees the basis of the decision at that stage. It pertained to a particular team and particular rates prevailing some 10 years ago. And it's also that approval can be read with Mr. Zuma's undertaking at page 85. Again, we say both the approval and the undertaking are in the context and given relation to the then prevailing charges and the expectation that that matter was going to proceed at that time. And since the re-indictment or reinstatement, if one needs to refer to that, it is that since that has taken place, there's a new private attorney has been instructed, a new team has been instructed, and we say that in those circumstances, what is provided for in September 2008 could never have been of application in the context of the matter going forward from March 2018 onwards. And we say that for that reason as well, the 2008 decision, even if it were to be regarded as lawful, cannot assist. Now, that leads us to the question of just and equitable remedy. And we say that the appropriate order in the first instance is a declaration that the state is not liable for Mr. Zuma's legal costs. We say that that's necessary to clarify the legal position in the view of the presidency's continued payment, not only in relation to his prosecution, but also seemingly in relation to other unrelated litigation. Second, we say the decisions that have been taken to fund Mr. Zuma's costs should be set aside, fund the personal costs. Mr. Zuma, we know, opposes this on two bases. He says he claims to have a legitimate expectation to receive state funding for his criminal defense. Secondly, he contends that state funding was necessary for him to protect, it was necessary for the protection of his fair trial rights. We submit with respect both of those conditions are unsustainable. Firstly, there can't surely be any legitimate expectation to receive an unlawful benefit. But even if that benefit were to have been lawful, there was always an understanding, the history of the matter reflects that Mr. Zuma always understood and appreciated that funding was a measure of discretion by the presidency, that new applications were to be made, and they were repeatedly made, we've seen that. And we've got there could be no legitimate expectation in these circumstances on the part of Mr. Zuma that the president would continue indefinitely funding his defense. And secondly, the suggestion that Mr. Zuma is not in a position to pay his legal, the suggestion, if it's there, it's not altogether clear, it's oblique, that Mr. Zuma can't afford to pay his legal costs is also, with respect, one that can't be taken seriously. We've detailed in the reply Mr. Zuma's income from 1999 to 2017. I think it's close to something like 30 million. And we would submit that in that context, he certainly is in a position to pay for an adequate legal defense. Thirdly, in relation to what is just and equitable, we say that that would extend and must entail an order directing repayment of all the amounts that have been received, that have been unlawfully paid. In our heads, we've referred to the authorities, Steenkamp, Allpay, which support the proposition of just and equitable remedy is one that fits the injury, it vindicates the rule of law, it corrects or reverses the public wrong and the prejudice that it has caused. And we say, unless there's strong countervailing considerations in that context, the default position remains that an order, or the default position is that an order should be made that whatever has been unlawfully gained under an unlawful contract be repaid or restored. And that's
well, Mr. Rosenberg, should the state attorney not rather be paid? Should we find the Section 3 not applicable and the payments unlawful and the decisions to pay unlawful? Should the state attorney not be ordered to take all necessary steps to procure repayment?
Well, that could be a formulation of the appropriate relief. But
because as you formulated, let me just put my difficulty.
Yes.
As it is formulated presently, I think you have two obstacles in your way. First of all, it is only in reply that you now seek an amendment of your notice of motion for an accounting. But that accounting you seek in the DA case. Even though this is a consolidated hearing, the two applications are still separate. So you are seeking relief against a party, Mr. Ali,
no,
who is not a party to these proceedings before us.
Justice Mayor, we submit that in truth, a just and equitable remedy, and one which is required to redress the wrong, is one which directs the beneficiary of the payments, the unlawful payments, to repay. The beneficiary is Mr. Zuma. It's not, in fact, Mr. Haley.
Now, I know that you are not seeking, and I'm referring to the claim for debatement, Mr. Rosenberg,
Yes.
not for the claim for repayment.
Yes.
But when it comes to the debatement claim, first of all, that was brought into reply. No such case is made out in the Crown papers, and that already disqualifies that relief. And secondly, that relief also enjoins Mr. Ali to participate in the accounting. But Mr. Ali is not a party in that application.
Yes.
That's the point I'm raising with you.
I appreciate
so
that.
the same objective will be achieved, and you will not, to put it that way, this court will not be a debt collector on behalf of the state attorney, because the state attorney is enjoined.
Yes. Yes.
And there may very well be, the state attorney has various functions when it comes to the recovery. And it is for the state attorney to establish the claim, and it's for the state attorney then to take the necessary steps to recover, and maybe even to compromise a part of it, and so on and so on. That all falls within the state attorney's powers. It's not for us to usurp the function of the state attorney.
Justice Mayor, I acknowledge the points that are made, and effectively that is an alternative and maybe a more fitting formulation of what's a just and equitable remedy. If I may, before moving on from this aspect, just make the following submissions. As far as what is framed in reply is concerned, that is merely in the light of what is put up in the answering papers, and more particularly what isn't put up in the answering papers, as a way to make the repayment more structured.
No, I understand why you did
that
it.
was the rationale.
No, I understand the method behind the madness, to put it that way.
And if I may, just in relation to to the madness of the method, it is an order which directs Mr. Zuma to account. I know that it has been formulated on the basis of with the assistance of his private attorney.
But there also I have a difficulty, Mr. Rosenberg, but I'm just debating with you. And that is, doesn't that fly in the face of normal onus of proof, where it is for the state to establish how much Mr. Zuma, should we get there, then it is for the state to establish how much Mr. Zuma owes them. It is surely not for Mr. Zuma then to prove how much he owes. That flies in the face of the normal burden of proof.
Yes. Well,
so it is a very strange type of formulation.
Yes, it was a formulation which I do submit was warranted in the exigencies of the matter, where there's somebody who is in a position to provide that information in motion proceedings and they haven't done it. And it's a mechanism aimed, as I've indicated, at crafting an appropriate and effective remedy. But your Justice, the formulation of directing the state attorney to take the steps that you've indicated does deal with certain of the problems, I acknowledge.
So that takes away those.
And the state attorney knows how much it paid, and when you look at the correspondence exchanged, they can pursue these claims.
As the court pleases. As to the competence of an order requiring repayment to vindicate or reverse a public wrong, there's well-established and also quite recent precedent in this court of orders to that effect. I can refer the court to the DA and the EFF's case against.
Yeah, we've seen that reference
you
in your
know the authority, and also the case of Corruption Watch and others versus the President.
Yes.
And Kasana versus Corruption Watch. You will also be familiar with that case, where the Constitutional Court equally ordered repayment of an amount unlawfully, which it held to have been unlawfully made to the former occupant of the NDPP position. And that was an order which this court had also made.
Yes.
And we say that Mr. Zuma has not put up any grounds, any facts, departing from the natural consequence of setting aside the decisions or agreement. He doesn't claim, as on the papers as we see it, that he would be unduly prejudiced by an order of repayment and that he can't repay. He's, as I've indicated, in a position where he requested that payment or that funding on the understanding that he would repay if he was unsuccessful, and it's reasonable to assume that he's made arrangements for that contingency. As far as the question of delay is concerned, Mr. Zuma contends that the application should be dismissed for unreasonable delay.
That submission, can you just wrap it up in about 10 minutes, please?
Yes, I'm not going to be long at all. I'll deal with that in reply to the extent necessary. The DA has explained, and I've sought to emphasize, that this application was prompted by the reinstitution of the charges against Mr. Zuma, and the DA's learning of that in March 2018. And the DA learning that the presidency's approach was that it was going to continue now funding the defense of those reinstituted charges on the basis now, we hear in the answering papers, of an agreement concluded in 2008. The DA was entitled to query the lawfulness of the presidency's decision to continue paying going forward. And at least in respect of that decision to continue paying, the basis of that decision, there can be no complaint of delay. And the declaratory relief and the setting aside of the 2008 decision is required in relation to that otherwise stated intention now to fund the 2008.
Just clarify one thing for us. Is the DA's application for review only brought in terms of PAJA, or is it also brought in terms of the Constitution? In other words, illegality.
It's brought on both bases.
And if we are with you on the interpretation issue,
Yes.
then that falls under illegality.
Yes. And 172 of the Constitution would require the court to make the appropriate declaration in regard to unlawfulness and to craft an appropriate remedy. And we would also just make the further submissions to whether the DA can be charged, aside from what I've already said, as with having acted unlawfully. It explains in its papers that since 12 September 2008, it knew that the DA, that the state was paying for Mr. Zuma's criminal defense, although it didn't know at that stage what the basis or the reasons for that was. We know that shortly after that answer to a parliamentary question, it was a rather opaque, brief answer, shortly thereafter, Mr. Zuma's prosecution was discontinued, and the prosecution was only reinstated in 2018. And until the presidency indicated in 2018 that it was continuing to rely on a decision taken in 2018, the DA couldn't have been, 2008, sorry. The DA couldn't have been reasonably expected to review a decision that for all effective purposes had lapsed and been overtaken with the withdrawal of the charges in 2009. And when the DA learned that in fact, in the wake of the re-indictment in March 2018, what the presidency's attitude to funding was, it wasted no time in launching this review. And in that context, I could also just point out in relation to the review application, the DA's review application, the DA says it had no knowledge time that review application was launched and thereafter that the state was funding Mr. Zuma's costs in that piece of litigation. And it wasn't only in March 2018 that the state attorney disclosed that those costs had been paid for. Those legal costs had been paid for after the withdrawal of the charges. That's not meaningfully disputed on the papers as we understand it, and the DA wasted no time in reviewing that decision when it learned it. We would submit that in those circumstances, there's no basis for you to find there was unreasonable delay in this matter, but even should the court find that there was an unreasonable delay, in particular regard being had to the provisions of 172 of the Constitution, the requirement in the face of illegality to declare the illegality and to make an order which is just and equitable, we would just draw the following factors to your attention in closing. This matter concerns patently a matter of considerable public importance, a series of unlawful decisions, we say, that resulted in the expenditure of millions of rands from the public purse for the personal benefit of the former president, who in fact has continued, or as the pattern of litigation has indicated, and as most plainly articulated by the Supreme Court of Appeal when summarizing the course and conduct of...
Yeah, we've read that submission in your heads. Further submissions?
Then the second factor is, as I've indicated, there can be no real contention of unreasonable or prejudice to Mr. Zuma, and for those reasons we submit that this is clearly a case where if there was a delay on the part of the applicant, it should be condoned in the context of formulating the appropriate remedy which is required in terms of the public interest. We submit that the relief that we've sought in the notice of motion is amended, and we will give attention also in the light of the court's conduct to formulating an amendment to the proposed amendment regarding the procedure for repayment. We would submit that DA is entitled to relief sought in the amended notice of motion, costs including the costs of the task.
Thank you, Mr. Rosen. All right, Toby?
Thank you, Lord. When I start with the chronology to head up to the court. Perhaps we should just move to the front. The court might give us a couple of seconds.
Yes, I think it would be more convenient if you move there.
Thank you, my Lord. So the court will have seen the chronology that I have handed up. I propose
we have also seen the joint chronology, so it's not necessary that you go through.
Yes, no, I don't propose to go through the chronology. Yes. What I propose doing is there are some grounds that overlap between what we say and what the TA says. I want to repeat those grounds in relation to the interpretation question of the Section 3 of the State Attorney. If the court is with us on Section 3 of the State Attorney, it's not necessary to enter a debate into compliance with the PFMA under Section 27.
So you two submit that that will be dispositive?
Yes, if the approval was unlawful at base, it's dispositive of the case. The PFMA argument is an alternative argument, and so is the equality argument, although the equality argument is necessary to frame the debate. And then the last point I will deal with. Remedy has been dealt with, and I know the questions that have come from the bench in relation to the propriety of an order, essentially in the form of using the court as a debt collector for the state attorney. Noted that. Then the last point I will deal with will be the question of delay. On the chronology, there are just a couple of points I want to lay emphasis on. The first is the pre-2005 scenario. What we know about the pre-2005 scenario, and this is the item on the 24th of November 2004, that what had happened is that although Sheikh was the criminal accused in this corruption trial, the state nevertheless decided to give funding separately to Mr. Zuma as someone with an interest in the trial. And that was the watching brief. And we know that decision taken on the 24th of November 2004. And we've given a reference there. And it's also necessary to note that that decision is a decision to appoint Tukten and Patel by the KZN state attorney. That's where the decision was made. And what seems to have been the logic behind that is that although at the time the funding decisions were approved, Mr. Zuma was deputy president of the country. At the time of the events described in the indictment, he was the MEC for Economic Affairs in KwaZulu-Natal, which is why this seems to have been located in KwaZulu-Natal. Then, in addition to funding him for a watching brief, he was also funded separately after his own indictment. And those two periods are important to separate. And this happens after the indictment. And the indictment, we know, is at page 2 of our chronology on the 20th of June 2005. And we know what he applied for. And this is the part we've highlighted. He applied for funding under Section 3.3 of the State Attorneys Act. Section 3, subsection 3 of that act. But we also know that in the advice that was contained internally from the presidency to the state attorney, there was a recorder of both Section 3.3 and Section 3.1. And the position was that the state attorney was of the view that he qualifies under Section 3.3. And the Ministry of Justice was under the opinion that he qualifies under Section 3.1. And when the presidency took the decision, it took into account both of those, Section 3.1 and Section 3.3. And that explains this apparent inconsistency, because in the explanatory affidavit filed with this court, the state attorney persists with his argument that he qualifies under Section 3.3. But regardless of whether it's 3.1 or 3.3, the effect of the matter is that it was common ground between the Justice Department and the state attorney and the presidency that he should be funded. The only issue was whether the basis for it is 3.1 or 3.2. And hence, in the attack that we are mounting, we are attacking the decision of the state attorney based on 3.3. We say the jurisdictional requirements of Section 3.3 were not fulfilled. So 3 more points to be added in the chronology is at page 3, where on the 29th of August 2006, the state attorney, Ms. Musidi, then agreed to Harley this time around. You remember that at the beginning, the principled agreement was that the funding will go to the advocates and that the legal work will be done at the state attorney's office. But that seems to have changed so that it's Mr. Harley who actually does the work, and the state attorney completely outsources the work from its office. And that we see confirmed on the 29th of August 2006 at page 3 of our chronology. And then after 2007, we know the big thing of 2007, at least as far as the EFF is concerned, is when Mr. Zuma becomes president of the ANC, and then certain further decisions are taken thereafter. What we say about that is in December 2007, he's elected as president, and shortly thereafter, 27th of December, he is indicted afresh by Mokotodi Mshe. And if you turn to page 4 of our chronology, by the 1st of August 2008, Ms. Mabanda already confirmed that an amount of 9.6 million rands had been spent on Mr. Zuma's legal fees to date. And we know that those were approvals from 2006 to 2008. And the main aspect of litigation there related to the lawfulness or validity of the search and seizures. And that is what seems to have been most of the amount spent on. And then on the 12th of September 2008, what the state attorney is advised by the presidency is that Mr. Zuma will be liable if he fails in the application. And that is a submission that's already been made by the DA. And we know that despite that, if you look at page 5 of our chronology, the item is item number 4 of the chronology. So we know 2 things, is that in relation to the Judge Nicholson application, the precondition was it would be repaid if Mr. Zuma fails. But that seems to be changed in 2009. On the 3rd of July 2009, the DG in the presidency instructs the DG of Justice Department, Mr. Simelane, to settle not legal fees, but a bill of costs. And the bill of costs was not contemplated in any of the decisions up until this point in time. It was always his legal fees to his own lawyers, but never the costs in the event that he lost. But the presidency in the office, Mr. Maviber, instructed the DG of Justice to settle the legal costs. But insofar as his legal fees were concerned, that decision is taken on the 15th of July 2009, where the state attorney, SABC, advises the presidency to approve payment of Zuma's legal fees for the Nicholson application and appeals. At that stage, it's 2.7 million. Now, at this point, what is crucial to note is that Mr. Zuma has lost that appeal before Nicholson, and lost it before the SCA. Despite the earlier precondition that if he loses, he would repay, and despite the fact that there was no provision for bill of costs, what happens is that the officials both decide we will settle his legal fees and also we will settle his costs. And that we see the 3rd of July, the 15th of July, and the 20th of July. And only thereafter, once they have made these decisions, do they come to ask for a legal opinion. Because we see the legal opinion from Advocate Shangisa only on the 10th of December 2009. And after 2009, this is now the period when Mr. Zuma is already president. And the period before, he had been deputy president before his dismissal. He was sworn in on the 9th of May 2009. What we see in page 5, which is what we call the post-2009 scenario, is that there is an approval from the presidency, and that is approved by Ms. Mosidi in the review application brought by the DA. And then on the 11th of February 2010, the presidency legal advises the presidency COO, that was Ms. Duarte, to approve payment of Zuma's legal fees in the DA's review application. And then at that stage, and we know that by 2008, the amount of 9 million rands had been announced. At this stage, in 2013, Mr. Khadebe discloses another 8 million rands spent between 2009 and 2012. We know, of course, that that subsequently was dismissed with costs, the appeal that was lodged by Mr. Zuma. And that takes us to where we are at the moment, and which is the last page of our chronology. 14th of February 2018, Mr. Zuma resigns as president. And Mr. Ramaphosa then discloses to Parliament that an amount of 15.3 million rands had been spent up to date on Zuma's legal fees. The amounts do not square up on our own calculations. We gave in the founding affidavit, as the court knows, an amount of 32 million rands that we say is our calculation of what has been spent so far. And there is no meaningful reply as to what actually the correct amount is that has been spent on this. So what does this chronology tells us? What it tells us is this inconsistency first about what the actual legal basis was. On the one hand, the presidency seems to insist that it was section 3.1. On the other hand, the state attorney says it was section 3.3. I will argue that section 3.3 does not help the state attorney. What it also shows is that there was a failure of proper record keeping and proper financial management. This entire funding of Mr. Zuma does not appear to have been properly managed at the state attorney's office. That also explains why there is no proper record filed. And the record that they filed is a very scant record, a couple of pages, which tells us nothing about what invoices were submitted by Mr. Hani, what procedure was followed to settle those invoices, and why the recoveries. If you take only the Nicholson situation as a separate example, where it's clear upfront that if you lose, you must pay, and he loses, but he doesn't pay. And the record does not fill those gaps. So it's clear that there was no proper prudent financial management, despite the stipulations of the PFMA. The third thing that we would submit, and that goes to our argument around equality. The third thing is that it seems to us that one cannot discount Zuma's political position. One cannot discount the fact that the reason this was moved from the state attorney, KwaZulu-Natal, and located in the presidency had to do with the fact that Mr. Zuma was deputy president, which is not the same test as considering how the liability arose in the first place, because the liability focuses on the performance of your functions. In this instance, not only do we say the performance had nothing to do with the office of the presidency at all, because the indictment relates to what he did in his personal capacity whilst he was MPC for Economic Affairs in KwaZulu-Natal. But the elevation of this case to the presidency is what we submit illustrates the kind of abuse of power. Is that basically Mr. Zuma was given preferential treatment because he was president of the ANC, deputy president of the country, and later on president of the country. This kind of treatment could not have been given to anybody else in South Africa except Mr. Zuma. And that is the case we make around the equality of treatment under Section 9. Could I then move to Section 3 of the State Attorneys Act? So, just to finalize the issue of the facts, what we know from Volume 2, at pages 85 and 86. So the state attorney first tells us what cases have been involved. So at page 85, we know it was the Mauritian case, the appeal, the Constitutional Court appeal, the Supreme Court of Appeal, and in total, there are 9 cases. They appear at 85 to 87. So that's the large scope of what we are dealing with. They have funded 9 cases. Now, not only have they funded these 9 cases, they have also funded the sub-branches of all of these cases. So it's one case, but each case, as we can see, and Mr. Jacob actually announced this at the trial, and it's a quote that we've relied on when he said this is a Stalingrad strategy. So what we know, although there are 9 cases in total, but each sub-case and the legal fees that were incurred when Mr. Zuma lost were funded by the state attorney. So basically, he got into a situation where he was not liable to pay anything, and that the taxpayer was liable to pay everything. And then, what we know about why the decision was taken is what we see at page 88 and 89 and 90 of the volume 2, and that's the state attorney's decision. Page 89, this is what they referred. It's paragraph 6.2. The magical phrase of this provision are, government, though not a party, is interested or concerned in the matter, or it is in the public interest. And then in paragraph 6.3, Mr. Chow says, it is therefore tried that an applicant for legal assistance will qualify once he or she satisfies either of the provisions, section 3.1 or section 3.3. And then he explains at page 90, paragraph 7.2, which of those two is relied upon. The principle that members of the executive authority or state government employees are entitled to legal representation at state expense for alleged contraventions performed in the course and scope of their official functions is partially recognized in the Treasury regulations issued in terms of the Public Finance Management Act. And then later on at page 91, paragraph 9, the aforementioned provisions of the State Attorney Act read with the PFMA and the Treasury regulations entitle members of cabinet or state employees who are liable for acts committed in the course and scope of their employment to legal assistance at the instance of the state. So although the requests were coming from the presidency, they were going to the state attorney. Under the State Attorneys Act, the state attorney has the ultimate say whether or not to fund or whether to appoint an attorney from the office of the state attorney. The decisions that were being made at the state attorney's office were decisions on the basis that Mr. Zuma was acting in the course and scope of his official duties. That is what the state attorney tells us. Now, Mr. Zuma also partially endorses this, because if we go to I think it's volume 3, at page 148. Sorry, at paragraph 148, page 140. Sorry, it's page 166, paragraph 148.
Page
166, paragraph 148. And so there he starts off by quoting the provisions of section 3.3. And then in 149, that a member of the national executive will be charged with this performance of functions in which government has an interest is most certainly of public interest, of the nature that must engage the state in its functions. The prospects of a constitutional lacuna, if the head of the national executive is arrested and charged with matters involving government, is most certainly a matter of public interest. And earlier on, at page 140, paragraph 36, this is what they say. The applicant's contention to the opposite is simply devoid of logic. The allegations are self-evident that Mr. Zuma abused or inappropriately used his official powers and duties for the benefit of Sheikh, his companies, and the companies which allegedly attempted to or bribed him. It is that conduct that is alleged to be inconsistent with the law applicable then and now. Now, paragraph 36 and 148 of the answering affidavit filed on behalf of Mr. Zuma tell us two things. First is that the legal basis, while they contend that they were entitled to state funding in section 3.3. Secondly, they tell us that the allegations are self-evident that Mr. Zuma abused or inappropriately used his official powers and duties for the benefit of Sheikh. So the starting point must then be to accept that factually what we are dealing with is a case where the charge is you have abused or inappropriately used your official powers and duties for the benefit of Sheikh. So Mr. Zuma is MEC for Economic Affairs. The indictment, those 18 charges, the indictment is you have misused your official powers or you have abused your official powers. Is that in the course and scope of your official functions to the extent that you would be entitled to legal funding? That seems to be the challenge that they are putting up. What they have relied upon is a case called K versus Minister of Safety and Security. And specifically, the paragraph there is paragraph 32. And that's the judgment that deals with the definition of course and scope. But quite crucially, and this is a point Mr. Rosenberg initially made, and quite crucially, those cases like K versus Minister of Safety and Security are cases that are determining liability of the state in intellectual claims. In other words, vicarious liability of the state in intellectual claims. And what had happened in K is that members of the police, I think it was a case of rape, had committed a serious offense, a criminal offense, in the course and scope of their employment. The question was whether or not that commission of that offense could be said to be in the course and scope of their employment. And the Constitutional Court says at paragraph 32, which I think is the main paragraph that they rely upon, our learned friends rely upon, the approach makes it clear that there are two questions to be asked. The first is whether the wrongful acts were done solely for the purposes of the employee. We know from paragraph 36 that it is common cause here that the indictment upon which they are alleging they are entitled to payment for is the abuse of office by Mr. Zuma for the benefit of Sheikh. And so that does not promote any public interest. It doesn't promote any governmental function as such. And then there is a later qualification in the judgment, which says that question is whether, even though the acts done have been done solely for the purpose of the employee, there is nevertheless a sufficiently close link between the employee's acts for his own interest and the purposes and the business of the employer. That again shows us that there must still be a sufficient link between the purpose of the employer and your actions. But if you invert the very reason why you are an MEC for Economic Affairs, There is no such a link. In fact, at that point, that linkage is broken. But the court need not go to any in-depth analysis of the authorities like K, because those authorities are determining the literal liability of the state.
And also state versus evils, not
Yes,
so,
precisely.
on which reliance is placed also.
Precisely. But they are determining the literal liability of the state for actions performed by its agent. What they are not deciding is who is to pay the lawyers acting for the individual. The cases closer to what we are dealing with here are cases like the President of the Republic of South Africa versus the Office of the Public Protector and others. And this is a judgment of the full bench of this case. And cases like Black Sash Trust versus Minister of Safety, Social Development, and that's a judgment of the Constitutional Court. And then the case of President of the Republic of South Africa versus the Office of the Public Protector, Economic Freedom Fighters intervening. If I can start with the last case, which is a case closer to what we are dealing with here. Who is responsible to pay the legal fees of a state official accused of abusing their office? In paragraph 54, this is a judgment by Justice Mlambo, and it's not an appeal unlike the first case. This is what he says in paragraph 54. It is in the nature of the conduct investigated that determines if the issue is personal or official. The President's argument boils down to this: any conduct of a member of the executive will qualify as official as long as it is investigated under the Executive Members Ethics Act. This is a misnomer. Members of the executive have private dealings in their personal capacities, and these are quite distinct from their conduct whilst pursuing the interests, objectives, and responsibilities of the departments they lead. Put differently, if that conduct falls outside the confines of the Constitution, more particularly Chapter 5 thereof, we fail to see how such conduct can be regarded as conduct of the head of state acting in his official capacity. Those words could well be transposed to here. When Mr. Zuma, as Mr. Macha says in his affidavit, abuses his office in order to financially benefit Mr. Sheikh, that conduct has nothing to do with the official responsibilities of Mr. Zuma as MEC for economic affairs. It is precisely the sort of thing that led this full bench in paragraph 55 to conclude, in the final analysis, the President's overall conduct leaves me with one option, but to find that he must be held personally liable for all the costs that were occasioned from 14 October 2016, when Faure stated that the previous public protector had finalized the investigation and signed the report. So, to come back to what we are dealing with here, if Mr. Zuma's conduct on the indictment is abuse of official office, and it is common cause that those are the facts, it is inappropriate to construe section 3.3 as suggesting that would be regarded as cause and scope, because cause and scope must imply some bona fides, some good faith in the pursuit of the objectives of your employer or the objectives of your official office. But where you invert that very relationship, in other words, you act directly in conflict with that relationship, then you are not entitled to the kind of protection that the state would ordinarily give policemen, for instance, who may exceed their responsibilities, but you can see it was in the context of an arrest, or policemen who were defending themselves, they happened to shoot someone, but you can see it was in the course and scope of their functions. So, if that is so, that we would submit is dispositive of the primary argument raised by Mr. Zuma, that simply because I, at the time, was an MEC, therefore it follows, as a matter of logic, that I must have done everything in the course and scope of my official duties. The full bench of this division makes it clear that you cannot draw that lip. But beyond that, there is another judgment of Black Sash Trust. It's a new judgment delivered on the 27th of September 2018, again deciding the question of personal liability for costs.
Do you have the reference first?
Yes, my lord. It is, but I've got the SAFLE reference if you don't mind.
Yes.
It's 2018 ZACC case number 36.
2018?
Yes, 2018 ZACC, and the case number is 36.
Thank you.
27 September 2018. And the passage we would like to emphasize is paragraph 12. The inquiry's report, and this is what they say, finding that the minister's failure to disclose this information was the fear of being joined in a personal capacity and being mulcted personally in cost has not been and cannot be faltered. The inference that she did not act in good faith and in doing so is irresistible. At best for her, her conduct was reckless and grossly negligent. All that is sufficient reason for a personal cost order. So we know that if you split the responsibility, you act in conflict, you are responsible for costs. If you abuse your office, or you act recklessly or grossly negligently, or you do not act in good faith in the pursuit of your official duty, you must take responsibility for the cost. And then the last judgment, which is the judgment in President of the Republic of South Africa versus Office of the Public Protector. And I think we've referred to this in our heads of argument. If not, the citation is 2018, volume 2, SA 100. And the paragraph we would make reference to is paragraph 190, where what this court, again, a different full bench to the one that decided the public protector case, but also make the same principle that if you are a president with constitutional functions and you abuse those functions, then you must pay the cost in your personal capacity. And this is what they say. Our view is that the president had no justifiable basis to launch the review application in the circumstances. And then they say, in doing so, he was reckless and acted unreasonably. Our view is that this is a proper case where a personal cost order is justified and should be granted. So in sum, if you are reckless, or you are unreasonable, or you are grossly negligent, or you act in a way that shows that your conduct are in conflict with your official responsibilities, then you are liable for that litigation on your own. So section 3.3, insofar as the state attorney is correct that its fulcrum is cost and scope. When cost and scope is abused, then you are not within section 3.3. You should be paying those costs in your individual capacity. So we would submit, in addition to the submissions that have been made by our learned friends around the meaning of section 3.1, section 3.3 also simply does not help the president. They will, as you have seen from their heads of argument, they have also relied on the Treasury guidelines.
Before you go to the next point, we know that it's about 4 minutes past 1. We'll adjourn and then we'll resume at 2 o'clock.
Yes.
Court adjourns.
No. But The problem is that if the charge against you is like abused your office, there's no basis.
Yeah, actually, no, the evidence of yeah, it's referred to this particular case, but it was okay.
No, it's not talking about this one. I thought it was a decision about this case.
Your conduct.